Imagine this. An army officer in uniform commits a crime in broad daylight. A police officer witnesses it. Can he actually put handcuffs on that soldier? The answer involves the Constitution, a 150-year-old law, and a battle between two of India's most powerful institutions. Let's get this straight first. Yes, technically, the police can arrest an army officer. No Indian law gives the military blanket immunity from civilian law enforcement. But in practice, it almost never happens. And when it does, it triggers a constitutional crisis. Here's why. India has two parallel legal systems that govern military personnel. First, civilian law. The Indian Penal Code, the BNSS, traffic laws, property laws. These apply to every Indian citizen, including army officers, when they are off duty and acting as private individuals. Second, military law. The Army Act of 1950 governs the conduct of armed forces personnel. Under this act, the Army has its own courts, called courts-martial, its own investigation process, and its own punishments. Now here's where it gets complicated. When an army officer commits an offense, who handles it? Under Section 475 of the BNSS, previously Section 549 of the old CrPC, if a person subject to military law is accused of an offense, the central government decides whether the case goes to a civil court or a court-martial. That decision isn't made by the police. It's made at the government level. So what happens in the moment, on the street? If an army officer commits a cognizable offense, like assault, drunk driving, or even a serious crime, a police officer has the legal right to make an arrest under the BNSS. But here's what actually happens in practice. The moment an army officer is detained or arrested by police, it immediately escalates. The officer's unit is informed. The local military hierarchy gets involved. The Judge Advocate General branch, the Army's legal wing, steps in. In most cases, the Army takes custody of the officer from the police, and the military conducts its own internal proceedings through a court-martial. The police, in practice, often defer to the Army, not because the law requires it, but because of institutional protocol, political sensitivity, and the sheer complexity of military jurisdiction. This isn't theoretical. There have been real cases where the question came to a head. In several instances involving road accidents, brawls, and even serious crimes in cantonments and civilian areas, police have detained army personnel, only for the cases to be transferred to military jurisdiction within hours. The most sensitive cases involve crimes committed inside cantonment areas. Cantonments are quasi-sovereign zones. Police typically need military permission to even enter and investigate. And then there are cases under AFSPA, the Armed Forces Special Powers Act, in force in parts of northeast India and previously in Kashmir. Under AFSPA, Army personnel cannot be prosecuted in civil courts without prior sanction from the central government. This has led to decades of controversy, with alleged human rights violations going unprosecuted because that sanction was never granted. At the heart of this issue is a fundamental constitutional question. India is a democracy with a civilian government controlling the military. That means the army is not above the law. It is accountable to the Constitution. The Supreme Court of India has repeatedly held that army personnel are not immune from civilian law. In landmark judgments, the court has said that AFSPA cannot be a shield for crimes, and that the government must grant prosecution sanction in genuine cases. But the reality on the ground remains murky. Institutional loyalty, national security concerns, and the reluctance of governments to prosecute their own military create a system where accountability moves slowly, if at all. Here's one more important distinction. Off-duty, in civilian clothes, acting as a private citizen, an Army officer has no special protection. Police can arrest him just like anyone else for traffic violations, property disputes, domestic issues, or any civilian crime. On duty, in uniform, acting under military orders, that's where military jurisdiction kicks in strongly, and police interference is extremely rare and procedurally complex. The uniform changes everything, not legally, but practically. So, can police arrest an Army officer in India? Legally, yes. Practically, it's complicated. Under AFSPA, almost impossible without government sanction. India walks a careful line, respecting the military's unique role in national security while maintaining the constitutional principle that no one is above the law. The police have the power, but whether they use it and what happens next depends on politics, protocol, and the kind of courage that goes far beyond a uniform. If this surprised you, share it, because most Indians don't know.